All right, good morning. All this meeting is called to order. Mr. Trillman, has anyone signed up for public comment?
Yes.
All right, let's see. We're going to jump straight to agenda item 3. No cases to reconsider under agenda item 3.
Correct, no cases.
Under agenda item 4, tax liability cases, no cases on 27 or 28.
Correct, no cases.
Nothing on agenda item 5 or 6. Under agenda item 7, we have one wage claim case on docket 27. No cases on docket 28 pulled for additional discussion.
That is correct. There's one case on docket 27 pulled. It's case number 23-063241-3. Commissioner Esparza.
We should remand this case. The appeal tribunal ruled that the employer filed a late appeal to the preliminary wage determination order, but did not hold a hearing allowing the employer to provide testimony on the issue of timeliness. A review of the documentary evidence in this case indicates that the employer may have paid twice for wages allegedly owed once directly to the claimant and once through a TWC bank levy. Prior to its late appeal, the employer had been involved in multiple conversations with TWC staff while trying to resolve this matter. In fact, the employer appealed the same day it received an email from TWC accounts examiner that discussed referring the case for an appeal. Because the employer disputes the facts set out in the order of dismissal and the request a hearing in its appeal to the commission, we should remand this case for testimony on timeliness issue and for merits testimony if appropriate.
The decision is correct. The employer filed its appeal to the preliminary wage determination order several months after the appeal deadline that was provided to them. The determination was mailed to the employer's correct address of record, and the employer did not allege non-receipt of the determination during the appeal period. Since the employer has not provided evidence that their appeal falls under any exception to the timeliness rules, the WCAT decision properly dismissed the appeal as late. Affirmed the WCAT late employer appeal $2,423.20 in wages owed.
Timely appeal rehear.
We have not yet achieved a majority vote.
We'll agree with the chairman to rehear.
Thank you. We will rehear the case. That was the only case pulled for additional discussion on docket 27, none pulled on docket 28. You should have received the wage claim short form dissent lists for dockets 27 and 28.
I move we accept staff recommendations on the remaining wage claim cases on both dockets 27 and 28.
I second the motion except for those cases which I am dissenting as reflected on wage claim short form dissent list for docket 27 and 28.
I concur with the chairman's motion, except for the cases on which I am dissenting was reflected in a wage claim short form dissent list for dockets 27 and 28.
Motion passes with the exceptions noted. Let's move then to agenda item 8. Consideration of unemployment insurance cases. Please proceed when you're ready.
Beginning with docket 27.
Case number 3229040, Commissioner Trevino.
The AT decision should be modified. The claimant had good cause for missing AT1, as a hearing was not scheduled for over a year after the claimant filed her appeal. Additionally, while I do not contest that the claimant received benefits to which she was not entitled due to her failure to timely submit her proof of employment documentation, the claimant was dealing with a serious personal medical issue at the time and submitted the required documentation a few months later. And submitted the required the claimant also stopped filing her payment request as soon as receiving the request to provide proof of employment. Therefore, repayment of the overpayment would be contrary to the equity and good conscience, such as a waiver should be granted. Modify the AT, claimant established good cause for AT1, ineligible for PUA benefits beginning 1/24/21, overpayment, grant waiver.
We should modify the AT decision. First, we voted on a previous docket that the claimant had good cause for a non-appearance. Concerning PUA eligibility issue, the claimant failed to submit the required employment documentation within the required period and did not explain why. Furthermore, she received an overpayment of PUA benefits. Since the overpayment arose as a result of a factor within the claimant's control, waiver of the overpayment is not justified. Accordingly, we should modify the AT decision. The claimant had good cause for a non-appearance. The claimant was not eligible for PUA benefits, overpayment, deny waiver of the overpayment.
Reverse the AT, good cause, claimant eligible for PUA benefits, no overpayment, void waiver determination.
Short form dissent, please.
We have not yet achieved a majority vote on all of the issues.
Ma'am, I'll agree with the chair.
Thank you, sir. And I have your short form dissent.
Case number 3556624, Commissioner Trevino.
The AT decision should be set aside. While I don't dispute that the claimant did not establish good cause for missing AT2 and failed to file a timely petition to reopen AT1, the FPUC overpayment at issue in this case is void on its face. Therefore, the AT decisions should be set aside and the underlying FPUC overpayment determinations should be voided. The FPUC overpayment determination was the only issue because the claims department ruled that the fraud and forfeiture provisions applied to the claim, and therefore the claimant was not eligible to receive FPUC benefits. However, this commission overturned the fraud ruling in a separate case. Therefore, there is no basis for the finding that the claimant was overpaid FPUC benefits. Set aside AT decision and void the FPUC overpayment determination.
We should modify the AT decision. Regarding AT3, the claimant established good cause for a non-appearance because she was away from home due to an ill family member. Regarding AT2, the claimant failed to establish good cause because she missed the hearing due to not checking the mail. As to the timeliness of the claimant's petition to reopen, the claimant provided no reason for filing her appeal 4 months late. Since we do not have jurisdiction to consider the underlying merits, the AT1 decision should remain in full force and effect. Modify the AT decision. The claimant had good cause for missing AT3. Claimant did not have good cause for missing AT2. Late petition to reopen overpayment.
It appears the overpayment here may perhaps stem from TWC's error in which the agency misinformed the claimant she needed to report her work study wages. We should resubmit this case to verify the underlying testimony. So good cause for AT2 and AT3, timely petition to reopen, resubmit.
We have not yet achieved a majority.
Ma'am, I'll agree with the chair.
Thank you, sir, and we will resubmit the case.
Case number 3631107, Commissioner Esparza.
We should modify the AT decision. I agree that the employer established good cause for missing the AT hearing. Concerning the job separation, the claimant quit, citing dissatisfaction with her working conditions. Although the claimant alleged concerns about supervisor micromanagement, her claims lacked merit. Correspondence between the claimant and her supervisor suggests repeated willingness by her supervisor to assist and foster the claimant for success. Furthermore, the claimant's contention that her supervisors were attempting to suspend her without HR involvement is again flawed. Claimant was merely provided a verbal warning addressing performance deficiencies. During a later meeting to address the claimant's concerns, she became indignant and quit. Since the claimant was never advised that her job was in jeopardy and chose to resign when continued work was available, her suspension or her separation was voluntary and without good cause connected with the work. As such, we should modify the AT decision. The employer established good cause for missing the AT hearing, voluntary leaving, no charge back, adequate employer response.
The decision is supportable. I won't dispute the finding that the employer had good cause for missing AT1. Regarding the work separation, the claimant provided firsthand testimony that her supervisor targeted her and used profanity toward her. The claimant spoke to HR about her concerns and requested a transfer to another position. HR told the claimant that they would look into a transfer for her, but they never followed up with the claimant. The claimant's supervisor continued to target the claimant and attempted to suspend the claimant without pay in a meeting without HR being present, even though HR was required to be present when suspensions were issued. Due to her supervisor's continued inappropriate actions and the employer's failure to address the claimant's legitimate concerns, The claimant had good cause connected with the work to quit. Affirm the AT. Employer had good cause for AT1. No voluntary leaving, chargeback.
Good cause, voluntary leaving, no chargeback, adequate employer response.
Short form dissent, ma'am.
Yes, sir.
Case number 3690-692, Commissioner Trevino.
This case involves a continued claim while the claimant was working for a gig economy employer in self-employment. As such, there was no separation from employment, and the claimant's continued claim should be voided. Set aside the AT decision, void the continued claim.
We should affirm the AT decision. The claimant ceased working due to complications with his vehicle. Since the claimant stopped working when continued work was available, his separation was voluntary and without good cause connected with the work. As such, we should affirm the AT decision, voluntary leaving overpayment.
Set aside the AT, void the continued claim, no overpayment.
Short form dissent.
Yes, sir.
Case number 3698-932, Commissioner Esparza.
We should affirm the AT decision. The claimant was discharged for excessive absences in violation of the employer's attendance policy. Claimant was aware of the policy and knew it could lead to termination. The employer provided a record of the claimant's attendance violations while the claimant gave inconsistent testimony about the reason for termination. Claimant alleged that the final absence on December 15th of 2023 was due to miscommunication with his manager regarding a half day. However, records show the claimant only requested time off beginning December 16th of 2023, and the employer had no record of a request for the December 15th day. Because company policy requires 2 weeks notice for time off, and the claimant had been previously warned that further attendance violation would result in termination, he was discharged for misconduct connected with the work. We should therefore affirm the AT decision, misconduct, no chargeback.
The decision is not supportable. Although the employer alleged that the claimant was discharged for a final absence was on 12/5 of 2023, the claimant was not actually discharged until an incident that occurred on 12/15. The claimant testified that after a dispute about whether he was given permission to leave early on 12/15, since his vacation was starting the next day, the claimant showed up at work and met with his managers and HR. When the claimant tried to argue that he had previously been given permission to leave early, work early that day, his supervisor told the complainant that he was being discharged. When the claimant asked why, his supervisor said that he was being a squeaky wheel. The employer only presented testimony from the HR rep, who, despite being present for the meeting where the claimant was discharged, did not dispute that the claimant's version of the events. Simply putting, whether he had been previously given permission to leave early does not constitute misconduct connected with the work. Therefore, the employer did not establish that the claimant was discharged for misconduct. Reverse the AT, no misconduct, chargeback.
Misconduct, no chargeback.
Short form dissent, ma'am.
Yes, sir.
Case number 3712-480, Commissioner Trevino.
The decision should be modified. The claimant was discharged based on allegations that he acted unprofessionally while interacting with other employees that he supervised. The claimant provided consistent firsthand testimony about his management style, and the employer only provided secondhand hearsay testimony to support their allegations that the claimant mismanaged his position. Therefore, the employer has not met their burden of showing that the claimant was discharged for misconduct connected with the work. Modify the AT, no misconduct, chargeback, sever adequate response.
We should modify the AT decision. Despite receiving prior warnings from professional workplace conduct, the claimant was terminated when he engaged in condescending communication with a subordinate, leading them to feel belittled. Since the claimant was warned that further workplace incidents could lead to termination, his continued improper behavior constituted misconduct connected with the work. As such, we should modify the AT decision, misconduct, no chargeback, adequate employer response.
No misconduct, chargeback set aside, adequate employer response.
Short form dissent.
Yes, sir. One moment for a clarification. Commissioner Trevino, you said to sever the adequate response. The chairman said to void it or set it aside. We need a consensus on that. It would be appropriate to void it or set it aside.
Oh, okay, I'll go ahead and agree with the chair.
Thank you very much. And I have your short form dissent, sir.
Thank you.
Case number 3726-388, Commissioner Trevino.
The AT decision should be reversed. The claimant was employed by a PEO and was informed by the client company that she was assigned to her assignment had ended. During that meeting, the client company called the PEO and a representative told the claimant that they would contact her if an assignment became available. The claimant had no way of knowing that the representative did not have her information and that she was under the reasonable impression that she had made the required report for reassignment. Additionally, though the claimant signed paperwork including the reporting requirement, the paperwork was not given to her, so she could not refer to it to understand that she was required to take further action before being offered another assignment. Under the circumstances of this case, since the claimant was not actually given written notice and a written instructions to contact the PEO for a new assignment, and since the complainant reasonably believed that the phone call to the PEO constituted reporting for the reassignment, and she was not offered additional work, the claimant was discharged for reasons other than misconduct connected with the work when her assignment ended. Reverse the AT, no misconduct, chargeback.
The AT decision should be affirmed. The claimant read and signed written instructions on how to report back for further assignment with the employer. The instructions also notified the claimant that unemployment benefits could be denied in the event of noncompliance. In sum, the weight of the evidence established that the employer satisfied the requirements of Section 207-045I of the Act, and the claimant's failure to report back for further work as instructed constituted voluntary quit without good cause connected with the work. We should therefore affirm the AT decision, voluntary leaving, no chargeback.
Voluntary leaving, no chargeback.
Short form dissent.
Yes, sir.
Case number 3731-346, Commissioner Trevino.
The AT decision is not supportable. Regarding the timeliness issue, the claimant stopped filing payment requests after 6/12/21, and the PUA program ended in Texas on 6/26/21. Yet this determination was not issued until 8/2/21. Therefore, the commission's delay in issuing the determination should be considered commission misinformation, and the claimant's appeal should be deemed timely. Regarding the claimant's PUA eligibility, the claimant was sent a notice on 4/23/21, giving him 90 days to provide proof of employment, and the claimant submitted his proof of employment on 4/27/21. Since the claimant complied with the commission's notice request prior to the deadline provided, the claimant was eligible for PUA benefits. Reverse the AT, timely claimant appeal, PUA eligible beginning 1/24/21. In the alternative, I could agree that the commission records clearly showed that the claimant responded to the notice prior to the deadline and provided the requested proof of employment. The AT decision should be set aside and the determination ruling the claimant ineligible to receive PUA benefits should be voided.
We should reverse the AT decision. The claimant's late appeal should be considered timely because the underlying determination is void. The claimant submitted the required documentation for his continued PUA claim within days of the proof of employment notice being issued and months prior to issuance of the determination. Since TWC was in actual receipt of the documentation of employment within the time required under federal law, we should reverse the AT decision, timely claimant appeal. The claimant was eligible for PUA benefits January 24th, 21, and void the PUA ineligibility determination.
Timely appeal, claimant eligible for PUA benefits.
Thank you. We have a unanimous decision.
Case number 3739900, Commissioner Trevino.
The decision should be modified. I won't dispute the good cause issue. However, regarding the job separation issue, the employer appeared at the AT1 and could only offer secondhand testimony that the claimant was discharged for insubordination. The employer's witness provided no details about the alleged insubordination and had no information about whether the claimant had any prior warnings. The employer also failed to provide any documentation that detailed the reason for the claimant's discharge. Therefore, the employer did not meet its burden of showing that the claimant's discharge was for misconduct connected with the work. Modify the AT, claimant did not have good cause for AT1, no misconduct, chargeback, void adequate response.
The AT decision should be modified. Regarding good cause, the claimant was notified via electronic correspondence that paper documents were going to be delivered to her. Therefore, she should have known to expect them, and her failure to attend the hearing was without good cause. As a job separation, the employer testified that the claimant was fired for insubordination and not eligible for rehire. The employer's position is supported by a letter from the employer to TWC and file documents. As the only party to attend the hearing, the employer's testimony should be given greater weight. Accordingly, the claimant's actions constituted misconduct connected with the work, and we should modify the AT decision. The claimant did not have good cause for a non-appearance, misconduct, no chargeback, sever adequate employer response.
No good cause, misconduct, no chargeback, sever adequate employer response.
Short form dissent, ma'am.
Yes, sir.
Case number 3803910, Commissioner Esparza.
We should affirm the AT decision. The claimant testified that she quit due to medical issues. However, fact-finding statements, she alleged that the reason she quit included stress, burnout, and feeling she was not a good fit for the job. The claimant did not address her health concerns with HR prior to quitting, nor did she provide medical documentation to the employer. Furthermore, she did not request FMLA or other medical leave, which would have allowed her time to address her health. Thus, because the claimant was not advised to quit and did not allow HR an opportunity to address her concerns, the claimant quit without good cause connected with the work. We should affirm the AT decision, voluntary leaving, no chargeback.
The decision is not fully supportable. The claimant resigned due to a medically verifiable illness. She quit based on the guidance of medical professionals because the working conditions at her job were causing her severe health problems. The claimant provided medical documentation establishing that the stress of her working conditions, including an unreasonable workload that negatively affected her health, caused her to resign. Since the claimant's separation was due to her medically verified illness, she should be qualified for benefits, and the employer's account should remain protected from chargeback. Modify the AT, no voluntary leaving, no chargeback, MVI.
Voluntary leaving, no chargeback.
Short form dissent, ma'am.
Yes, sir.
Case number 3805884, Commissioner Esparza.
We should reverse the AT decision. The claimant, a long-term store manager, conducted a team building event with his assistant managers at his property where they blew up small appliances and shot firearms. The employer safety policy stated that possessing weapons or explosives while on company business was prohibited. The claimant admitted in fact-finding statements that he invited his team to his ranch to improve morale. While this event was not conducted on company property or during work hours, the store manager's invitation to an event to improve team morale, which benefits the employer, constitutes company business. This in turn created a liability risk for the employer. Thus, because the claimant violated the employer's safety policy by using explosives and firearms while on company business, he mismanaged his position of employment. We should reverse the AT decision, misconduct, no chargeback, adequate employer response.
The decision is correct. The employer discharged the claimant, a 21-year employee, based on an anonymous report of off-duty conduct at a private event the claimant held for employees at his ranch 8 months before the discharge. While the employer testified that they investigated and they concluded that the claimant acted unprofessionally and that the event was unsafe, they did not have any firsthand evidence of what occurred, could not show that any specific policy was violated, or that the claimant placed any employee's safety at risk. Therefore, the employer did not meet its burden of establishing that the claimant was discharged for misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
No misconduct, chargeback.
Short form dissent.
Yes, sir. And that was the last case pulled for additional discussion on docket 27. You should have received the UI short form dissent list for docket 27.
I move we accept staff recommendations on the remaining UI cases on docket 27.
I second the motion, except for those cases which I am dissenting, as reflected on UI short form dissent list for docket 27.
I concur with the chairman's motion, except for the case on which I am dissenting is reflected in UI short form dissent list for docket 27.
That motion passes with the exceptions noted.
Thank you. Moving to docket 28.
Case number 2856510, Commissioner Sparza.
We should modify the AT decision. The claimant testified that his job separation was due to medical concerns related to COVID. The employer confirmed that the excessive absences, including the time off for COVID, was the reasons for the claimant's job separation. Since a separation due to a medically verified illness does not constitute misconduct, the claimant should be qualified for benefits and the employer's account should be protected from a chargeback. As such, we should modify the AT decision, no misconduct, no chargeback, MVI.
The decision is not supportable. The employer discharged the claimant after he allegedly left work early without permission on his last day. However, the employer only presented secondhand hearsay testimony regarding the final incident. The claimant provided firsthand testimony that he did not leave work early on the day in question, nor any other day around the time of his separation. Therefore, the employer did not meet its burden of proving that the claimant was discharged for misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
Misconduct, no chargeback.
We have not received a majority vote, but let me double check. Misconduct, no chargeback. That was your vote, Mr. Chairman.
We'll agree with the chairman.
Thank you, sir. Majority vote is misconduct, no chargeback.
Short form dissent, ma'am.
Thank you, sir.
Case number 3399177, Commissioner Sparza.
We should reverse the AT decision. The claimant was discharged following allegations of sexual harassment. The employer testified that the claimant's termination resulted from a violation of the company's policy, which strictly prohibits any conduct that creates potential for harassment, including unwelcome advances, requests for sexual favors, or conduct of a sexual nature. The AT's rationale is not supportable because the employer's policy prohibits sexual conduct of any kind in the workplace, regardless of consent. The claimant admitted that he voluntarily touched the female coworker inappropriately and knew such conduct was prohibited at work. The employer took immediate action when the complaint was made and followed its disciplinary procedures, determining the coworker's account was true. Therefore, the employer has met its burden of providing that the claimant engaged in misconduct connected with their work by violating company policy. Accordingly, we should reverse the AT decision, misconduct, no chargeback, adequate employer response.
The AT decision on the merits is supportable, though the decision should be modified to name the correct employer. Regarding the job separation, the claimant was discharged because the employer alleged that he violated the employer's non-harassment policy and engaged in inappropriate behavior in the workplace with another employee. However, the claimant credibly denied the allegations of harassment, and though he admits to the inappropriate behavior, the individual involved was not discharged or disciplined because of the incident. Therefore, the employer has failed to establish that the claimant was discharged for misconduct connected with the work. Modify the AT, no misconduct, chargeback, change ER name and account number.
rehear for the employer to offer firsthand testimony or some kind of actual evidence of the final incident.
I'll agree to rehear.
We will rehear the case.
Case number 3587592, Commissioner Esparza.
The commission should rehear this case. First, I agree that the employer had good cause for its non-appearance. However, the circumstances surrounding the claimant's job separation need to be clarified. Specifically, the record is unclear on whether the claimant was discharged as a result of the workplace altercation or whether the claimant quit in lieu of returning to work. If viewed as a discharge, the parties should be questions about the claimant's participation in the workplace altercation, and moreover about the claimant's possible involvement in the incident as depicted on the on the employer's video. In contrast, if viewed as a quit, the claimant should be questioned about the employer's requirement to return to work after the suspension period and why the claimant did not return to work despite the continuing work was available. Since issues of material facts are undeveloped, a rehearing is necessary to fully develop the record about the nature of the claimant's job separation. The employer had established good cause for missing the AT hearing. Rehear.
The AT decision should be affirmed. I don't dispute that the employer established good cause for missing AT1. However, regarding the job separation, the conflicting employer testimony was not sufficient to establish misconduct. The employer suspended the claimant because he assumed that she was involved in a fight, yet the claimant repeatedly denies her involvement, which is supported by the employer's own video evidence. Additionally, when she attempted to return from suspension, the claimant was not given clear instructions about when to return. Therefore, the evidence established that the claimant was discharged for reasons other than misconduct connected with the work. Affirm the AT. Employer had good cause for AT1, no misconduct, chargeback.
Rehear.
We will rehear the case.
Case number 3646705, Commissioner Esparza.
We should affirm the AT decision. First, I don't contest the claimant's CA appeal was timely. Concerning the job separation, the claimant was terminated for engaging in an altercation with multiple coworkers. Although the claimant alleged that he was not the aggressor, multiple witnesses for the employer stated that the claimant started the altercation and confronted his coworkers instead of going to HR or a supervisor about his concerns. Since the employer's workplace violence policy prohibited threatening, intimidating, or behavior suggesting a propensity towards violence, the claimant's workplace altercation with coworkers constituted misconduct connected with the work. As such, we should find the claimant's CA appeal timely and affirm the AT decision, misconduct, no chargeback.
The claimant's appeal to the commission should be deemed timely. Based on the AT issuing a corrected decision after the claimant had filed his appeal, and the AT decision should be reversed. The employer discharged the claimant after a verbal altercation with coworkers. The claimant admitted to confronting two coworkers who he thought were making fun of him. However, he denied being aggressive or violent in any way. Rather, one of the associates physically threatened the claimant, so the claimant reported the incident to HR. The employer did not offer any firsthand testimony about the incident, and the claimant had no prior warnings. A mere verbal confrontation with coworkers, especially with no prior warnings, does not constitute misconduct connected with the work sufficient to warrant discharge. Deem the claimant CA appeal timely, reverse the AT, no misconduct, chargeback.
Deemed commission appeal timely, misconduct, no chargeback.
Short form dissent.
Yes, sir.
Case number 3680401, Commissioner Trevino.
The AT decision is not supportable. The claimant provided credible and consistent firsthand testimony that he turned in incomplete paperwork because he was instructed to do so by a supervisor. The supervisor acknowledged that the claimant was unable to complete the safety ride because of the supervisor's instructions to perform other duties and presented no corroborating testimony to support the supervisor's contention that he had not told the claimant or that he had not told the claimant to turn in the report. Additionally, even after completing the investigation, the employer delayed discharging the claimant for a month. Since the employer failed to meet its burden of proving that the claimant falsified the report, and since the employer discharged the claimant at its own convenience instead of at the end of the investigation, the weight of the evidence established that the claimant was discharged for reasons other than misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
The AT decision should be modified. The claimant was fired for falsification of records. The employer presented a witness who stated that the claimant admitted to his falsification in his presence. While the claimant offered varying details, the employer's evidence has been consistent that the claimant reported he had completed a safety ride, which was not the case. As such, the weight of the credible evidence establishes that the claimant's action constituted misconduct connected with work. We should therefore modify the AT decision, misconduct, no chargeback, sever adequate employer response.
This case should be reheard for the employer to submit the allegedly falsified report and to resubmit evidence that they previously submitted, but it is illegible. The record should be developed on the delay between the final incident and the termination.
We have not yet achieved a majority vote.
I can agree with the chairman.
Thank you. We will rehear the case.
Case number 3692-708, Commissioner Trevino.
This case involves a continued claim related to the claimant working as a marketplace contractor in self-employment. As such, there was no separation from employment and the claimant's continued claim should be voided. Set aside the AT decision, void the determination.
The AT decision should be affirmed. The claimant stopped performing work for a named employer due to personal reasons that were not related to the work. As such, the claimant quit without good cause connected with the work. We should therefore affirm the AT decision of voluntary leaving.
Set aside the AT, void the continued claim.
Short form dissent.
Yes, sir. And that was the last case pulled for additional discussion on docket 28. You should have received the UI short form dissent list for docket 28.
I move we accept staff recommendations on the remaining UI cases on docket 28.
I second the motion except for those cases which I am dissenting as reflected on UI short form dissent list for docket 28.
I concur with the chairman's motion except for the cases in which I'm dissenting is reflected in the UI short form dissent list for docket 28.
Motion passes with the exceptions noted.
Thank you, sir.
Thank you. We'll take a short recess. This is agenda item 9, fiscal year 2026 TANF and childcare allocations. Here it comes.
Good morning, Chairman, Commissioners, Mr. Cerna. For the record, Chris Nelson, Chief Financial Officer. This morning, you have before you the fiscal year 2026 TANF and childcare allocations in accordance with Chapter 800 of the TWC rules regarding allocations. The TANF allocation is in the amount of $74,404,408 and includes a small board distribution of $289,877. And the child care allocation is in the amount of $1,436,029,277. This amount includes the required 2% quality funds for the local workforce areas. Also included in the packet is a 4% distribution of quality funds in the amount of $59,834,553, a Minta distribution of $31 million, and a board strategic planning funds distribution of $98,000 based on previously approved commission action. That concludes my remarks, and I'd be happy to answer any questions.
Comments or questions?
None here.
No questions.
Is there a motion?
Chairman, I move that we adopt the fiscal year 2026 temporary assistance for needy families and childcare allocations as recommended today by staff.
I second.
It's been moved and seconded. Motion carries. Thank you. It's agenda item 10, BCY 2026 childcare performance measures and targets.
Good morning, Chairman, Commissioners, and Mr. Cerna. For the record, Allison Wilson with Child Care and Early Learning. In addition to the child care allocations and distributions that you just approved, you also have before you today the board contract year 2026 child care performance measures and targets for the average number of children served per day. These targets were developed based on the methodology approved by the Commission last fall to set child care minimum payment rates thresholds beginning with BCY 25. Based on the available funding and updated cost and case mix data, we are projecting to serve over 148,000 children per day on average in BCY 26. The materials in your notebook outline the individual targets for each board. Staff recommends the Commission approve the BCY 26 child care performance measures and targets as outlined. That concludes my remarks. Happy to answer any questions.
Comments or questions?
None here.
No questions.
Is there a motion?
Chairman, I move that we approve the board contract year 2026 child care performance measures and targets for average number of children served per day as recommended today by staff.
I second.
Motion carries. It's agenda item 11, 2025 RESEA state plan submission.
Good morning, Chairman, Commissioners, Mr. Cerna. For the record, I'm Suzette Robinson with the Workforce Development Division. Staff is seeking approval of the 2025 RESEA State Plan before you, which was prepared in line with U.S. Department of Labor guidelines. The state plan details the program's budget for the coming board contract year, which includes $25,266,504 in grant funds for BCY 2025, as well as $15,262,408 in carryover funds from prior grants years. The RESEA department plans to use these funds to grow the size of the team, help streamline the program process for RESEA customers, and expand the use of evidence-based services like subsequent meetings in line with DOL requirements. Staff projects that a combined 159,450 customers will be provided RESEA services in initial and subsequent meetings over the course of the next year. Staff has prepared this state plan document through a collaborative drafting effort, including the RESEA Department, Workforce Development, UI, and Finance departments. Staff has also incorporated advanced feedback from the Department of Labor on an earlier version. And we thank you for your consideration, and I'm happy to answer any questions that you may have.
Any comments or questions?
None here.
No questions.
I have a couple of questions. What's the due date of this report?
It is July 10th.
July 10th is the due date.
Yes.
Did DOL point out anything specific on their advanced review that has been incorporated into this report?
In one of the tables, we had the cost of services. There was a math error in the hourly wages. and then a couple of minor narrative comments, which we highlighted.
Very good. Couple more things. So I noted in the report, there's a reference to commission rulemaking. Is that rulemaking that we've already undertaken or rulemaking that will have to be undertaken somewhere in the future?
Rulemaking that will be undertaken in the future.
Okay. And so otherwise, does that then otherwise mean that parts of this report are subject to that rulemaking?
Yes, so we have, yes, the 8.8 million in contingency funds is conditioned upon rulemaking and an ability to implement whatever rules
Okay.
are established.
And, okay, I got it. And there's, I caught a few misspelled words. Y'all are gonna come back through this before you send it in. I found like
Yes.
3 misspelled words.
Yes, I believe those were already captured.
All right.
Yes.
All right. Is there a motion?
Chairman, I move that we approve the 2025 Reemployment Services and Eligibility Assessment State Plan for submission to the U.S. Department of Labor as recommended today by staff.
I second.
It's been moved second and motion carries. This is agenda item 12, RESEA fiscal year 2024 supplemental distribution. That's been postponed to a future meeting. We'll move then to agenda item 13, RESEA FY 2024 outcome payment incentive distribution.
So Texas has earned a performance outcome payment every year since 2022. The commission has approved to distribute these funds to local workforce development boards as performance and training incentives based on how well they provide services to customers. The discussion paper for your consideration distributes roughly 1.6 million of the 2.89 million performance outcome payment awarded to TWC by USDOL as incentives to encourage boards to continue improving their performance.
Any comments or questions?
No comments.
No questions.
Is there a motion?
Chairman, I move that we approve the fiscal year 2024 Reemployment Services and Eligibility Assessment Performance Outcome Payment Incentive Distribution Plan as described in the discussion paper and recommended today by staff.
Second.
Been moved second and motion carries. This is agenda item 14, RESEA fiscal year 2023 performance incentive reallocation.
For your consideration is a discussion paper to reallocate FY 2023 performance incentive balances for Panhandle, Concho Valley, and Deep East Texas as a contract amendment to BCY 2025 and require funds to be spent by February 28th, 2026.
Any comments or questions?
None here.
No questions.
Is there a motion?
Chairman, I move that we approve the Reemployment Services and Eligibility Assessment Fiscal Year 2023 Board Contract Year 2024 Performance Initiative Reallocation as described in the discussion paper and recommended today by staff.
I second.
It's been moved second and the motion carries. Thank you. So agenda item 15, board nominations.
Good morning, Chairman, Commissioners, Mr. Serna. For the record, Patricia Martinez, Workforce Development Division. Today, for your consideration, we have workforce board nominations for the following workforce solutions: Brazos Valley, North Central Texas, South Texas, Middle Rio Grande, Central Texas, Panhandle, and Permian Basin. Staff recommends approval on the presented nominees, and I'm here to answer any questions you may have.
Comments or questions?
None here.
No questions.
Is there a motion?
Chairman, I move that we approve the local workforce development board member nominees presented today for the following: Workforce Solutions Brazos Valley, North Central Texas, South Texas, Middle Rio Grande, Central Texas, Panhandle, and Permian Basin.
I second.
It's been moved second and the motion carries.
Thank you.
An executive director's report. Nothing. Is there any other order of business come before the commission?
Nothing here.
No, Chairman.
Is there a motion to adjourn?
Chairman, I move to adjourn.
I second.
It's been moved seconded to adjourn and we're adjourned.